Hello, Dr. Alevato and class. We're Group 5, and today we're going to talk about the Rolls-Royce case. We'll start with facts, issue, rule and analysis, and finally a conclusion. Hope you enjoy.
First of all, we will start by describing the facts of the case. The parties to the case are on the one hand Rolls-Royce plc versus the Deputy Director of Income Tax in New Delhi. In this case, we have a non-resident company incorporated in the UK which supplies aero engines and spare parts manufactured by them to many government organizations in India. The officer, in his records, argued that the Rolls-Royce had a business connection in India under Section 9, as well as a permanent establishment under Article 5 of the Double Taxation Treaty between both countries. Consequently, the officer argued that business connection and the permanent establishment came from an Indian subsidiary, Company R, which was having its offices in India, and that the marketing and sale of goods to Indian customers were carried out by the company through the subsidiary. Furthermore, survey operations were conducted at the subsidiary installations to find out the exact nature of the business activities carried out by the subsidiary and Rolls-Royce in India. The conclusion was again confirmed. Then, on the appeal, the commissioner said that the issue of notice under Section 148 for framing the assessment under Section 147 was valid, that there was indeed a business connection in India, and also that the company had a permanent establishment in India, within the meanings of Article 5.1, 5.2, and 5.4 of the Double Taxation Treaty between both countries, so that income was taxable in India. This is significantly important if we take into account that 75% of the profit was attributable to such sales. Then, the interest levied by assessing officer under sections 234A and 234B were also confirmed. As regards the issue of the case, we have determined several questions important to understand the case. The first issue questions whether the assessing officer was justified in issuing notice under Section 148 so as to frame an assessment under Section 147. Then, as regards the substance of the case, the most important questions are whether or not Rolls-Royce had any business connection in India within the meaning of Section 9.1. Then, whether the company had a permanent establishment in India within the meaning of Articles 5.1, 5.2, and 5.4 under the Double Taxation Treaty. Then, what is the extent of income earned in India which can be charged to tax? And finally, whether the interests under Section 234A and 234B are chargeable to tax. Then, as regards the rule for the case, the most important legal source would be, on the first hand, the Double Taxation Treaty between India and the UK, especially Articles 5.1, 5.2, and 5.4, which describe the conditions for permanent establishment, and Section 9, which explain what does classify as a business connection. Moreover, we have 148 and 147, which relates to the issuance of notice by the Commissioner, and finally, Section 234A and B for the assessment of the interest levied.
Now, regarding business connection, the domestic law says that there has to be a business connection in India in order to be taxed in India. However, the definition in the law is quite ambiguous and very broad. Therefore, the court looked at the case instead. And from the case, they found that the business connection has to be more than just doing business. It has to involve a relation between a resident subsidiary and a non-resident. And this relation shouldn't yield profits in the taxable territories, which in this case would be India. And the relation itself should be continuous, real, and intimate. And the income should accrue directly or indirectly for the non-resident. Before the new evidence came to light, the court still concluded that there was a business connection in India. It's solely based on the official agreement between the appellant and the subsidiary. However, with the new evidence, this was solidified in their mind. Now, this is because any sort of quotation had to go through the subsidiary first, and then after the subsidiary checked it, go to the appellant in the UK. And that just shows that there definitely was a business connection between the appellant and India. Now, regarding Article 5, Paragraph 3, it is quite similar to the old version of the OECD model that we have. However, for the interest of the case, and good for us, the court had to distinguish if there was auxiliary or preparatory character, and this is very difficult to do. However, the significant criterion for this is whether or not it constitutes an essential and significant part of the business, and the court examines this on a case-by-case basis. Now, the appellant argued that the main significant part of the business is manufacturing. However, the court examined the new evidence. First, they found emails and letters that show that the RIIL, the subsidiary, scrutinized proposals and orders, and in one case even signed the contract. At the same time, quotations were given to the RIIL first, and significantly, the employees are functionally responsible to the appellant. They were not only responsible for the quotations, but even in other activities like marketing, which are not solely of preparatory or auxiliary character, was performed by the subsidiary. Now, at the same time, the subsidiary had a certificate under the Foreign Corrupt Practices Act. Now, this certificate would not be given to an enterprise that only had auxiliary or preparatory character, and in meetings, they had a certain degree of authority as well. Furthermore, the employees also made suggestions for repairs and recommendations about further actions, and therefore the court concluded that the exclusion granted under Article 5, Paragraph 3 is not available to the appellant.
I will now analyze another important question of this case, which is whether Rolls-Royce had permanent establishment in India following Articles 5.1, 5.2, and 5.4 of the Double Tax Treaty between India and the United Kingdom. Going back to the facts of the case, we can recall that Corporation R had an office in India, more specifically New Delhi. That Corporation R was 100% owned as a subsidiary by Rolls-Royce, that the employees from Rolls-Royce could and often visited and went to the premises of Corporation R in India, and that even though Rolls-Royce was the one that maintained the premise and the one that paid for the operation and maintenance expenses, the premises were always occupied by Corporation R. Now, looking at Article 5.1 of the Double Tax Treaty, we see that a permanent establishment is defined as a fixed place of business through which the business of an enterprise is wholly or partially carried on. And there are three conditions. The first one, that there is the existence of a place of business, that this place of business is fixed and has a certain degree of permanence, and that the business of an enterprise is carried out through this place of business. The court found that just the fact that an enterprise has a certain amount of space at its disposal, which it uses to carry out its business activities, is enough to constitute a place of business. And moreover, that as long as Rolls-Royce could use the premises for business activity and had a certain control over these premises, this was to be considered a permanent establishment. In the present case, we can see that the three conditions are fulfilled with. First of all, we're talking about an office, which is a fixed place of business, and the facilities were in the name of Rolls-Royce, and they were being used, paid by, and available to Rolls-Royce in order to carry out their business activity and their business operation in India. The cost for maintenance was paid by Rolls-Royce, and moreover, the premises were always available to Rolls-Royce employees all the time. So consequently, we reached the conclusion that in fact, Rolls-Royce had permanent establishment in India following these articles. We're now faced with the question of what is the extent of income earned in India that is subject to tax. And to answer it, we need to look at Article 7 of the Double Tax Treaty between the countries, which tells us how to allocate the profits. And paragraph 4 states that when the profits are attributed to a permanent establishment, the law of the permanent establishment is the one to be followed. And in this case, it is that the profits attributed to this country are the ones that are going to be subject to a tax there. In this case, India. When we look at the company's profits breakdown, we see that the marketing activities took place in India, and hence they are subject to tax. However, the manufacturing activity, which was worth 50% of the total global activity profits of the company, was not subject to tax based on the case that you can see on the screen, which established that when the manufacturing takes place in a different country from the sale of the same good, it shall only be taxed in the place where the manufacturing activity takes place. And the same happened with research and development, which also took place abroad and was worth 15% of the company's global profit. Lastly, for the benefit of India, all of the other companies' profits were deemed to be taxable in India because they were said to have indirectly or directly accrued through the permanent establishment in India, so through the negotiations or discussions that took place there, even if the contracts were signed abroad. So as a conclusion, the profits that were attributed to India and hence taxable there were 35% of the global profits and not the 75% that was initially attributed to them.
Now, moving on to Article 5, Paragraph 4, it gives three options that may deem a dependent agent to be a permanent establishment of the principal. Now, the appellant argues that they fall under the first two because the subsidiary has no authority to negotiate or conclude contracts. However, the defendant and eventually the court argue that they fall under Article 5, Paragraph 4c in any case, because the subsidiary habitually secures orders in India for the appellant. Now we can see that because Indian customers cannot send orders directly to the UK, they have to go through the subsidiary first. And that shows that they're more than just a post office, and thus they're deemed to be a permanent establishment of the appellant.
To sum everything up, we see that through the surveys conducted by the tax authorities, it was held that the premises of RRIL constituted a place of establishment for RRPLC under Article 5.1 of the Double Tax Treaty, as well as 5.2F and 5.4C, given that it is used for routinely receiving and soliciting orders for RRPLC, the activities not being ancillary, but core to the business such as marketing, negotiating contracts, and selling products. Basically, it acted as a sales office independent agent for RRPLC in India. With regards to the attribution of business profits to India, the tribunal relied upon the Supreme Court decision of the Al-Murdavi case. The tribunal said that the profits are to be computed as if the PE was a distinct and separate business, dealing wholly and independently with the enterprise of which it is a PE. Moreover, they are to be treated as directly attributable to the PE and thus taxable. Profits that come from the PE's active part in negotiating, concluding, or fulfilling contracts, even if other parts of the enterprise participated as well, are to be indirectly attributable to the PE and taxable as well. After said allocations, the tribunal, through the landmark case of the special bench on the Motorola case, followed the global apportionment and attributed 35% of the global profits as being income taxable in India. It was consequently concluded that they had to pay interest on the taxable business income. They also extinguished the payments of ALP to RRIL because it was accepted by the transfer pricing officer, and thus no further attribution could be done. It is also important to note that the many activities carried by RRIL were not part of the agreement, and thus it cannot be said that the entire profit accruing to the RRPLC is remuneration paid to RRIL. The main takeaways from the case is the need for multinationals to critically examine the nature and extent of operations in India, not only from the actual operations but also from documentation. In this regard, the mere payment of ALP to the dependent agent does not extinguish tax liability of the foreign company in India, unless the dependent agent is being compensated for all functions performed, assets employed, and risk undertaken. Otherwise, revenue authorities will always be tempted to claim a share of the global profits. We hope you enjoyed. Any questions? Leave them in the thread below.